Greatest of evenings, mornings, or afternoons to you. My name is Mario A. Reed, and I'm the managing law partner for the law offices of Mario A. Reed, also known as the Lumarti Law Group. And I'm doing a series of videos which is going to explain some key elements of estate planning. The first one that I'm going to be tackling is none other than the revocable living trust. And I'm going to repeat that, the revocable living trust. Our office hears from numerous clients who consistently ask, why do I need a revocable living trust? Why can't I simply do a last will and testament as well as a transfer on death instrument or what's known as a transfer on death deed in other states? And there's several reasons as to why it is not ideal to rely on just the last will and testament nor a transfer on death instrument at all, but I want to go through the top 10 reasons why every adult over the age of 18 should have a revocable living trust. So I am now going to provide a list, and it gives you a bit of the cliff notes, but we're going to go through all 10 of these different reasons. So the first reason why every adult over the age of 18 should have a revocable living trust is because a revocable living trust allows you to control the property from the grave, whether that be the real property, such as your home, your insurance proceeds that come from your life insurance policy, your proceeds that come from your checking account, your savings account, or your retirement account. Having that revocable living trust as the owner, such as at the case with the house, or as the beneficiary, such as the case with the life insurance, the bank accounts, and the retirement accounts, it enables you to control the property from the grave. Now, a lot of people are saying, what does that mean? Well, as an example, for the real property, which I'm responsible for, that's in Lansing, Illinois, because that property is in the name of a revocable living trust, I'm now able to specify that should I die before my daughter reaches the age of 22, the property has to remain in the name of the trust until she turns 22. I have connected a life insurance policy which will pay out to that trust, and those funds will be used to pay the monthly expenses associated with that property. That's how the property will be able to stay in the name of the trust until my daughter turns 22. Even if she's not living in it, even if no one's living in it, the funds that come from the life insurance will be used to pay for all the utilities, the homeowner's insurance, as well as the property taxes. That's me controlling the property from the grave. I'm controlling the life insurance policy proceeds, and I'm controlling the real property. I then have specified that if my daughter turns 22, she then gets to decide what happens with the property. However, if she elects to sell the property, she then has to use her mother as the realtor. That's another means of control which I've put in place. Once the property has been sold, the proceeds are not to go to my daughter, but instead to also be deposited into the brokerage account that's in the name of the revocable living trust. Those funds are then to be invested in the S&P 500 via the exchange trading fund with the stock symbol SPY. And then every subsequent year on October 29th, which is my birthday, the trustee is to sell half of the gain from the previous year and distribute that to my daughter. When she passes away, it then goes to her children. And that is how I have control and will control the property from the grave, whether it be the real property or whether it be the personal properties such as the money. I'm specifying what can and can't be done with it. And that's how I control the property from the grave. You don't have that luxury if you have a transfer on death instrument. Furthermore, you don't have that luxury if you're using a last will and testament. You're limited in what you can do, and specifically, you can simply bequeath those assets to an individual, but you can't control the assets from the grave. The second reason why every adult over the age of 18 should have a revocable living trust is because it provides you with anonymity from outside parties who don't need to nor deserve to know about your wishes. One of the things that many people are unaware of is that a last will and testament is public. Once an individual who's done the will dies, that last will and testament is to be filed with the clerk of the circuit court for the county in which the individual was last a resident of. That makes that last will and testament public. The same holds true for a transfer on death instrument or a transfer on death deed. That document is to be recorded with the county agency where the property is situated, and that makes that information public. The details of my trust are not public unless I share them on a video like this. However, if I decide to change those instructions, change the people who are a part of that trust agreement, none of that information is public. It's all private. So I'm able to maintain anonymity related to my wishes, which is not the case with your last will and testament and your transfer on death instrument or transfer on death deed. The third reason why every adult over the age of 18 should have a revocable living trust is because it prevents your loved ones or your beneficiaries from having to go through the probate court process. Now, a lot of people will say a trust can be challenged, and that's accurate. But even when a trust is challenged, it's not challenged in probate court, it's challenged in chancery court, which is a different process, and there's a much different threshold which must be met on the part of a challenging party. But the best part is that so long as there is no one who's challenging, you don't have to go through that probate court process. Whereas for people who have never gotten their affairs in order, even if there's no one challenging anything, oftentimes the assets, especially the real property, still has to go through the probate court process. So having that revocable living trust in place helps ensure your loved ones are on a path to avoid probate court. The fourth reason is because it helps your beneficiaries avoid having to deal with your creditors upon your passing. So I tell everyone that I hope to die penniless with over $1 million worth of debt. And the reason why is because once I die, that debt is the responsibility of my estate. That means any assets which belong to my estate can be used in order to satisfy those debts. But because of the fact that all properties that I'm responsible for and all financial accounts which I currently own all have the trust listed as the beneficiary or the existing owner, that ensures that when I die, the debt that belongs to my estate will continue to be the debt of my estate and not be mixed up with any of the assets that are currently owned by the Revocable Living Trust. So by having those trusts in place, it helps ensure that your beneficiaries are going to be able to avoid having to deal with your creditors when it comes time for you to pass away. The fifth reason is because a trust enables you to develop a succession plan regarding the assets. So even if a beneficiary dies after you, the asset still goes to who or whom you want and not that beneficiary's estate. Our office is currently working with 3 different clients who the person who owned the property did a transfer on death instrument. They passed away, and unfortunately, the beneficiary died shortly after the original owner. Because of this, that beneficiary's interest now belongs to that beneficiary's estate, and that means it goes to that person's heirs. So imagine, if you will, that you choose your child to be the beneficiary for your house using a transfer on death instrument. You pass away on January 5th of 2025, and then unfortunately, your child passes away on March 5th of 2025, 2 months after you. Well, now, because that child didn't get her or his affairs in order, that child's beneficial interest now goes to that child's heir. And if that child was married, your house now belongs to your son-in-law or daughter-in-law when you probably didn't want that to be the case. More than likely, you would have wanted it to have gone to your siblings or to a different child or even a niece or a nephew in your bloodline. But because of the fact that you didn't use a revocable living trust, it simply goes to the heir of your chosen beneficiary. And that's oftentimes not what most people want, especially when we get into the conversation of an ex spouse who now becomes the beneficiary. So imagine, if you will, you passed away and your child passed away 2 months after you. That child never married, never had children, but that child's father or mother, who you happen to divorce 30 years earlier, is still alive. Now that house belongs to your ex-wife or your ex-husband by virtue of the fact that that's the heir of your heir. And this is something which most people are completely clueless about, because if you've never lived through it, you don't have that experience. This is why it's so important to have a revocable living trust, because even if your child passes away after you, if that child does not have any children, you can then specify that you want for that child's interest to then go to your siblings, your nieces, your nephew, maybe even your spouse, if you have one. So that's the benefit of a trust versus a transfer on death instrument versus a last will and testament, and versus doing nothing. Number 6 is that a trust helps minimize income tax liability for the beneficiaries. One of the biggest elements of a trust is that you can create a trust fund. What that looks like is that money that comes from a life insurance policy or from the sale of a house or from your retirement account can be mandated to be used to purchase the S&P 500 via what's called an exchange trading fund with the stock symbol SPY. In doing it that way, you can then specify that each and every year you want for that beneficiary to receive up to whatever the capital gains tax threshold, the long-term capital gains tax threshold, meaning that it was held for longer than a year, which is that year. So for the year 2025, the long-term capital gains tax threshold is approximately $58,025. So you can specify that your beneficiary is to receive a payout commensurate with the amount up to the long-term capital gains tax threshold, which in this case would be $58,025. By setting it up that way, your beneficiary won't have to worry about the trust paying any capital gains taxes. Number 7 is that the trust enables you to provide for multiple generations, not just a single individual or individuals. Many people who set up transfer on death instruments name their children as the beneficiaries. Then when they pass, the property transfers to the children. The children get together and decide that they want to sell the property. And then at the conclusion of the sale, each of them gets a check for $50,000. And then they take that money and spend it within a year or 2 years' time. And now the generational wealth, as it's oftentimes referred to in the form of the house, never ends up making it past one generation. That's what using a transfer on death instrument as well as a last will and testament oftentimes results in, as opposed to the situation I told you earlier about one of my trusts. That money is now going to last forever because the beneficiary is only receiving 50% of the gain for any given year, and then it's going to the next generation perpetually. So that's how you can provide for multiple generations instead of it just going to one or two or three people who are your children, who then take the money and then blow it without it ever making it to your grandchildren and great-grandchildren. The number 8 reason is that the revocable living trust allows you to create specific requirements and expectations which must be met prior to a distribution. Our office works with numerous clients who want to make sure that their children don't just become lazy by virtue of getting a check every year. So they've required that their children have to still be gainfully employed. They have to be contributing to society in a meaningful way. They cannot have a drug or alcohol addiction. And if they do, the funds can only be used for rehabilitation and rehabilitative purposes. This is the benefit of a trust. you can put controls in place to ensure that future generations don't just become lazy or decide to live off of their trust fund, but instead are contributing to society in a meaningful way. That's the benefit of a trust, where again, if you simply leave an inheritance via a will, you don't have that luxury. Number 9 is that it ensures that while you're alive, you are always in control of whatever assets belong to the revocable living trust. So for the brokerage account that I've created in the name of one of the trusts that I'm responsible for, I get to make all of the investments. I get to make all the deposits. I get to make all the withdrawals. For the real properties that are owned by those respective revocable living trusts, if I decide that I want to do a home equity line of credit or a refinance or sell the property, as the trustee and the beneficiary, I not only get to call all the shots and make all of the control decisions, but I also still get to reap all the benefits. So even though it's in the name of a revocable living trust, I haven't relinquished my control, autonomy, and discretion over the assets which belong to the trust. And then last but not least, number 10 is that having the revocable living trust eliminates cross liability between the trustee, myself, and other assets I may own, or liabilities in which I may own individually and personally. And that's a mouthful, but let me break it down. All of the vehicles in which I own still are in the name of Mario A. Reed. And the reason why is because those vehicles are liabilities. They have a debt which is depreciating. I'm sorry, the asset, the vehicle is depreciating faster than the debt that's associated with it. Most vehicles are underwater the second that you drive off of the lot. So because of that, there's always the risk that the creditor can come knocking. When the creditor comes and knocks, they might get a deficiency judgment, meaning the difference between what the vehicle sells for at auction versus what the loan was that you were still owing on that vehicle. And that's the deficiency judgment, which goes not only against the vehicle, but against you, the individual. In the case of me having a trust, when they put that judgment against myself, because I don't own any real property, they can't now go after any of those pieces of real property. So I've eliminated the cross liability between a debt for myself and the property. The other thing is let's say that I'm responsible for 3 different properties and something bad happens at the property at Lansing. I get a lien or a violation because I decided to do work on the property without having the proper permits. So Lansing now gets a $1,500 judgment from the administrative law court saying that I did work on the property without having the proper permits. If I own all of those properties, the 3 different properties in my name, Lansing can put the $1,500 judgment not only against the Lansing property, but also against the South Holland property and the Monique property. Whereas because the property is owned in the name of the trust, they can only put the judgment against the property and the trust. And because the trust doesn't own any other pieces of real property, it won't go against those other properties. This is the benefit of having the trust, and more importantly, having a different revocable living trust per property. So those are the 10 different reasons why I highly recommend that every adult over the age of 18 have a revocable living trust. Honestly, I could spend another 90 reasons giving you the benefits and advantages of a revocable living trust. The fact that it's revocable means you can change your mind. That's a huge benefit versus an irrevocable or other types of trust. The list goes on and on and on, but I wanted to do a video which allows for people to quickly be able to review it, then discuss it with your family, maybe even turn this video on when you have your family over for the holidays. But a lot of people say, well, what are the pros and cons of having a revocable living trust? And the answer is there aren't many cons. Now, I will be upfront and transparent that you should be working with a licensed estate planning attorney, meaning an attorney who concentrates in the area of estate planning, and that's going to cost. There's a fee and an expense that's associated with it. That is a con in a lot of people's opinion. However, I can tell you from personal experience that it's much less than having to go and work with a probate attorney. Our firm charges over $5,000 to go and deal with the probate process. A revocable living trust is oftentimes less than half of that amount. So for people who say us attorneys are just trying to get over, I promise you, most attorneys are going to earn way more money if they go through probate. So it's to our advantage financially not to offer and talk about the benefits of a revocable living trust. One of the last things that I want to leave you with is that having a revocable living trust is not only for the wealthy, it's far more beneficial and advantageous for those of us who don't have millions of dollars because it ensures that all of our wealth will make it to our chosen beneficiaries. So I want to thank you for tuning into this first video. Please go to the YouTube page for the Law Offices of Mario A. Reed, and that's where I'm going to be posting these videos. I'm going to be posting them regularly. I'm going to make it a goal to post one per month. And I'm going to talk about a variety of topics that our practice area covers. We cover real estate, probate, estate planning, and business. And my goal is to provide you with accurate information, which is based on the law, that comes from someone who's lived it and experienced it on numerous occasions. We'll cover individual circumstances and situations which many people never knew existed. And I'll also build up to the point where I talk about the stuff you want to hear about. So if you post comments underneath the videos, we'll be able to work through it. But the goal of the Law Offices of Mario A. Reed is to educate. We refer to ourselves as the Education Esquires, and that's what this video is about. I'm looking forward to taking this journey. I'm looking forward to helping expand the education and information and awareness surrounding not only estate planning, but all areas related to the law and just general. We'll talk about things like investing. I'm not a financial planner. I'm not a stockbroker, but I'm someone who's invested, and I want to share the information I've learned, not to persuade you to go with what I've done, but just to inform you and encourage and inspire you to start on your journey. It's not hard. It's just a lack of knowledge on the part of most of us. So again, I want to thank you for tuning in. My name is Mario A. Reed. I'm the managing partner for the Law Offices of Mario A. Reed, and I appreciate you learning and getting educated. As always, please know that knowledge is power, but only when applied. I'm looking forward to sharing that knowledge and you applying it. Have a great one all and take care.